Hello and thanks for joining us for our weekly video update. In today's video, I would like to answer the questions we get regarding wills and trusts and in relation to real estate or other assets. The will, as we all know, is the written document instructing the people that are alive on how a deceased person would like their assets to be distributed. So the will usually gives the heirs who or the beneficiaries. Sometimes it's not a direct blood relative or adopted child or anything like that. It could be just gifted to a caretaker or a friend. So the will would tell us, the people that are alive, what the person would like done with their assets once they pass away. The trust, on the other hand, is typically in effect while the person is alive, because the trust would address assets as well, but sometimes it sets up a special needs trust for a specific child or grandchild or family member. And sometimes the trust will also talk about distributing income from the assets, not actually distributing the assets themselves. So we'll go over how these two would overlap sometimes, and we'll also go over the main question that people want to know is what happens to real estate when the real estate was already addressed either in a will or some other instrument or a deed, and now the person or one of the persons that are interested in that real property have created a trust after the fact. So we'll talk about what that question really means and whether there's any impact to co-owners, for instance. That's typically what people want to know. Let me first talk about the real estate part of it, because that's what we do at our firm the most, and the other assets will be handled by estate and probate attorneys. So if you have questions regarding wills or trusts, you are better off speaking to a wills or trust attorney, who are sometimes called estate attorneys or probate attorneys. So I will give you what knowledge I have based on my experience, and this is for educational purposes only, as always. The will is not going to go into effect until the person dies. That's the main distinction. And the will does not address income from properties or anything like that, since it doesn't go into effect until the person dies. So the trust, on the other hand, is an instrument or document that would explain to the people that are involved through a trustee's actions. The trustee will be the one that will carry out the intention of the trust. So the trust can say income from my real property, such as rental income, would be distributed to one of my children only. And that's it. So that's essentially what a trust can do. And then the trust can have other layered conditions, preconditions, and also distributions to different beneficiaries, depending at times, depending on their age. They're not supposed to get that income until they turn 25. Sometimes there's a special needs trust, as I mentioned before, where certain income must go to a specific child because that child has special needs. And there will be several conditions on how the financial aspects are to be verified, how the allowances are supposed to be given out to that child, and to whom will the money be given out if the child is incapacitated to a certain point. So those are the main distinctions, is that usually people use a revocable trust, which means that they can cancel the trust at any time. They don't have to keep it going. Since they're still alive, they can cancel it at any time. And the beneficiaries don't have any say in it. We also have a different kind of trust called the irrevocable trust. And it's exactly what you think it is. It's the opposite of the revocable trust, meaning that it's supposed to be set for life. However, people can still change their mind. Of course, things happen. And if they do change their mind, rather than being able to just dissolve the trust completely, like canceling the trust or changing things in the trust, they must then get the consent of the beneficiaries that were named inside the trust before they can make any changes. Or at times they might have to go to court to do it if there's no agreement. So I think most people, so this is why I think most people do tend to use the revocable trust so that they can have more flexibility to make modifications and maybe even cancel it outright in future if they don't like how their kids are behaving. All right, so we've covered the essential differences there, and then I'll also mention the common terms that you might hear people talk about: the corpus of the trust as opposed to the income from the trust. And essentially when they're talking about the corpus in Latin, it just means the body. So it can mean different things in different contexts. In this case, they're talking about what assets are inside the trust. That will be the corpus. In my example, it will be real estate. That will be the corpus of the trust. And the income, such as the rental income flowing from the real estate, will be the income. And that's all there is to it. So the trust typically does not dispose of the corpus. Most people would dispose of the corpus in their will because they're alive to oversee things. So generally, the income is enough for the beneficiaries while the parent is alive. And then once the parent dies, the corpus will be dealt with, either according to the trust or according to a will. There are many benefits, as you know, of using a trust to kind of control things, and then having a will as the final document that takes over when the person dies. At times, people have what we also call a pour-over clause or provision in their will, or sometimes people call it a pour-over will. The pour-over just means that any assets that the person forgot to put inside the trust while they were alive, when they die, the assets automatically become part of the trust assets. And that's what that clause is for in the will. And that's because if the trust is having certain provisions about how the corpus is to be handled, the corpus of the property, then it's nice to have that pour-over provision so that you don't leave anything out. And you'll then have to go and divide everything according to the trust provisions. So these two can work together, the will and the trust. They work together well when done correctly with the help of an estate attorney. Now, the other question that people want to know is, well, if I set up a trust, would I be the one in charge of giving out this income and all of that? Yes, you could be the trustee of the trust. You alone could be the trustee of the trust. It's always wise to have a substitute trustee or some other secondary trustee that would step in if something would happen to you. And it's also nice sometimes to use maybe a legal firm to be the trustee if there's significant amount of monies involved, significant amounts of assets involved, significant amounts of generations. Maybe you have a lot of generations involved and you want this trust to go on for a long time. Then you might use a law firm or an organization because they're going to outlast a lot of the family members, and also because you need that neutrality so that when family members are demanding income, the trustee can say, I'm sorry, I have to go by the book. I have to go by the trust terms. I cannot give you any allowance outside of the normal period that's set in the trust. So you could be the trustee if it's only one or two assets that we're talking about. Of course, you can be the trustee, and then if you do pass away, then the trust will still be followed as long as somebody else knows about the trust, and they know where to find the actual document, because even if you put real estate into a trust, the only record that's public is just the fact that the real estate was transferred to a trustee, which would then still be you. If the record is found that the real estate was transferred to a trustee, but we cannot find the actual trust documents, then we don't know exactly what you intended to do with the corpus or even the income. So you'll be the only one that would know that, unless you shared it with a substitute trustee or somebody else that you really trust that would actually speak up once you pass away and show that document to everyone. So that's how the trusts work. The wills are a little bit simpler and more common because people understand that once they die, certain things need to happen. But still, most people don't have a will anyway. That's how I see it. But maybe it's because the people that are coming to us are already coming to us because of the complexities in dividing up the assets. And that's typically because there was no will or it was poorly written, not written in the form that the state accepts or that the probate court would accept. And so I would guess, if I were to just guess, based on just what I hear from other lawyers and from my experience, I would guess that maybe 50% of people have wills and 50% of people don't. Even people that have some quite significant assets. Sometimes they just don't get around to doing it, and then they pass away. The main question that this video was going to answer, I'm going to address now, which is what happens to real estate if one of the parties, whether it's the original owner, whether it's the heirs, one of the parties goes ahead and creates a trust and puts that property into a trust. Well, let's first break down again how the trust looks, and then that would inform us what happens to the property. Remember, whoever created the trust is the, let's say, benefactor. So that's the person that actually owned the property first. So let's say dad created a trust and put himself as the trustee, or puts his sister as the trustee, then dad is going to be the owner still. He's still the owner of that property. So let's say dad created a trust and puts himself as the trustee, then the property document that will be prepared is a deed that transfers the property from dad's name into the name of dad as trustee of ABC Trust. So the property is now owned by the trust, and the trust is really just owned by dad as long as he's alive, if it's a revocable trust, and the beneficiaries might have a chance to get income from the property, and maybe even have a chance to get the property itself once it passes away, if that's written into the trust documents. All right, so that's step one. So let's say dad transferred property into ABC Trust, but this time the trustee is his sister. So his sister's name is going to be the one on the deed when the property is transferred into the trust. So he'll say, this property is being conveyed to Mary Smith as trustee of ABC Trust. Now, Mary Smith's name might not match dad's name because maybe she got married, and so she doesn't have the same last name as him. So everybody might be caught off guard and say, well, who is this and how is she involved? Well, she's not the owner of the property, even though it says transferred to her, because it says transferred to her as trustee of ABC Trust. So ABC Trust is still the owner of the property. And who owns ABC Trust? Dad, who is the trustor. So the trustor is essentially still the owner in the back end because he has a revocable trust. So he could still control and change his mind. He could cancel it altogether, anything he wants. Now, irrevocable is different. So that's why they have to all agree when changes need to be made. The trustor is at the mercy of the beneficiaries to agree with him to make changes, him or her. Or then he might end up in court having to ask a judge to agree for him to make changes. So, most people do not use irrevocable trust unless they're absolutely sure what they want to happen and they don't want any kids messing with it. So they will make an irrevocable trust to prevent any beneficiaries from fighting over anything. They just set it in stone at once and leave it like that. The second layer to that question is that dad may have actually had real estate which he never created a trust for. He never put it into a trust or anything, but then he passed away without a will, or maybe with a will. But he passed away and the property went to his heirs, who would be, let's say, 2 kids that he had. So he had 2 sons, and the property would go to them, legally speaking, and his share of the property would go to them regardless of who else would co-own with him. And so what happens if one of those sons then creates a trust and puts that property into his trust? So we're looking at dad who never had a trust, and his two sons inherited from him, but they hadn't yet put all the documents together, and one of the sons went ahead and created his own trust. So one of the sons created his own trust called the XYZ Trust, and then he moved forward putting that property address inside the trust information in the trust documents. So the son will then record a document into the property record saying, the property on 100 Main Street has been conveyed to Adam Jones as trustee of XYZ Trust. So that is going to show up again in the property records, and people can see it and they'll wonder, well, that property was owned by John Jones, and there's no conveyance to Adam Jones, or maybe there was a conveyance to Adam Jones and his brother, and now we're seeing another document saying that the same property has been transferred to Adam Jones as trustee of XYZ Trust. That tends to throw people off because they're wondering who owns it and what's going on. So in the first scenario that we came up with, where dad owned the property and then he transferred it into trust, dad can still do whatever he wants with that property if it's a revocable trust. And the beneficiaries that he named inside the revocable trust to get the corpus, remember the body of the property, they'll be the ones to end up getting the actual real estate, as long as that's what the trust says. If it says it's triggered when they turn a certain age, then they will get the property. If it says that it's triggered upon dad's death, then they get it at that time. So that's pretty straightforward because the property still belonged to dad, even though he put it in a trust. In the second scenario, dad never had a trust, but one of the kids created a trust afterwards and put the property in his own trust, in the kid's trust. So what happens to the other brother's rights and interests? Well, actually, the trust does not affect the rights of the other sibling because the law still recognizes that that sibling has a right to the real estate. What it does do is it complicates things a little bit when they're trying to sell or anything like that. Depends on the trustee of the XYZ trust. If there is an outside trustee, then the outside trustee has to be involved when they're trying to sell the inherited property. Sibling A is going to be by himself because he doesn't have a trust. So it's very straightforward for him to just sign over all the closing documents to be able to sell the property. But because most properties are not, duplexes or multi-unit that are easily divided, they co-own the property together. So he needs his brother's trustee to then agree, to sign the documents when they're trying to sell the property. So that's the only thing that changes, is the party that's going to be legally able to convey the property. It will be the trustee, and if the brother had put himself as a trustee, which most people tend to do, then the brother will be the one signing as trustee of XYZ Trust. If he had chosen a company to do it, then the representative, an authorized representative of that company, would be the one to come and sign the documents to be able to sell the inherited property. So that's really the effect. It doesn't really affect a lot of things. Sometimes inside the trust document, the father or whoever originally had a trust, if the person set up a trust, sometimes they do the divisions very clearly inside the trust, saying once I pass away, whatever the trigger event is, or once the kids turn 30 years old, I do want my son Adam to get 70% of this property, and I want my other son to get 30% of this property. So you have to honor that if there was a trust set up by the original owner of the property. who would be the grantor, or let's say the trustor, or the benefactor, or whoever it is that is giving. So he's the giver at this time. And so that's what we look at, is what are we talking about? Who owned the property first? Did that person have a trust? Then we have to look at that trust. Was the trust still in effect at the time that the person died or that the trigger happened? So the things that are really important to know is who owned the property first. Is it this particular trustor that you're talking about, or did the trustor inherit the property jointly with other people? If the trustor inherited the property jointly with other people, his transfer of the property into a trust should not affect the other people's interests or rights. However, it just makes it a little bit more complicated, as I said, if they're all trying to do transactions regarding that property, because the trustee of that particular person's trust has to be involved. That's really the answer that I have for you for this video. I hope that I've made the explanations clear. There are different benefits to having a will and a trust, and they work very well together if everything is planned out, keeping all of the things or the wishes that you would like in mind. And I would suggest that you speak with an estate attorney to create something that works for you. Some people just simply create trust to protect the properties and add layers of protection in case they're exposed to litigation in the future. So there are many benefits to it, and some like to create it to simplify the will, so that the will has to look at the trust, and some have it in place just for the purpose of simplifying the will, because the trust would already take care of a lot of provisions that are complex, like age limits, like special needs situations, and dividing things up in different percentages. You can still do that in a will, but people simplify it by doing it inside the trust first, and then the corpus of the property will be divided according to the trust terms if it's in there. If there's nothing inside the trust terms, then the corpus of the property will be divided according to the will. That's pretty much all I have for today's video. I hope this has been helpful to you, as always, to at least get you thinking along the lines of what you might consider doing and what questions you might have for an estate attorney and maybe for a real estate attorney. And again, we just do this for educational purposes. We cannot answer any questions on YouTube because of all the lawyer ethics rules and all the different laws that we must abide by. I would say if you have specific questions, be sure to send them to us on our website, and we will try our best to answer them, or at least refer you out to somebody that might be able to help you. Thanks as always for watching the video. Have a wonderful weekend, and I'll talk to you next time.